They're going to have to do it within a short statute of limitations. Out here in California, statute of limitations for fraud can go as far as 5 to 7 years, which is quite long. In the jurisdictions we use, we're using them as low as 1 year. That means for them to sue you and for them to pursue that trust, which now holds all the assets offshore, they're going to have to sue you within 1 year of creation of that trust and funding of that trust. So what happens is they're going to have to pursue their domestic litigation first against you because they cannot discover assets till the end of the lawsuit. There's no ability for them to find out what you have until after they win that lawsuit. They cannot go in just before filing a lawsuit and ask you. Well, they can ask you. You don't have to tell them what are your assets. You're not going to tell them, right? They filed a lawsuit. Unless the lawsuit involves financial transactions that involve your wealth of assets, or unless there's punitive damages involved where they can somehow at the end request maybe financial data, they have no access to that. They have to wait till they win the lawsuit and go after what's called a debtor's examination. They have to drag you in and under oath ask you what are your assets. But that's going to mean what has transpired. They're going to have to first have a cause of action. They're going to have to file a summons and complaint against you. You have 30 days to file an answer. Then you're going to have all the pretrial settlement conferences, discovery, interrogatories, all those things drag on and drag on. You're looking at what, a year, year and a half? It goes to trial, and then you lose. What do you have then? Appeals, everything back and forth. It's been maybe 2 years now. Now they finally get you in for debtor's examination. What did they find out? Well, a year ago, or 2 years ago, or 3 years ago, you set up this offshore trust. Well, so much the better for you, because now if they want to pursue their offshore trust, they're going to have to relitigate that case on the merits in the foreign jurisdiction. That means they're going to have to fly all their exhibits, witnesses, everything, to places like the Cook Islands in the South Pacific, out in the middle of nowhere, maybe Isle of Man, Bahamas, places that they don't want to be because these are countries that have laws that were set up for the benefit of judgment debtors. That's the ones that pay their taxes and fees and expenses. So they're not going to do any laws against the judgment debtors. The burden of proof is very, very strong. Generally, in the U.S. court system, it's just preponderance of the evidence. That means all they have to prove is 51% most likely that they're going to prevail and they win. For fraud, say 75%. Just clear and convincing evidence that they could win, they can prove up fraud. Well, in our foreign jurisdictions, we have what's called beyond reasonable doubt. And that's a criminal standard. That's like back when you had the O.J. trial and they had to prove beyond reasonable doubt that he committed what he committed. And it's very hard to prove because you have to get 12 jurors together to prove unanimously that they committed beyond reasonable doubt an act of fraud or fraudulent conveyance. That's going to be like a criminal sanction. So now we have the venue all the way in the Cook Islands. We have the burden of proof very, very strong, right? Beyond reasonable doubt. We have the statute of limitations only 1 year and the expensive cost of litigation. And so even then we think they might be able to prevail. It's going to be very, very difficult. The only ones that they've ever been successful with, and these of course became notorious cases, they became cover of Tax Lawyer magazine because these were difficult cases that went through their court system. But these are people who set up their plan like 2 days before and filed bankruptcy 4 days later. Of course they deserve to have their asset protection structure unwound, and it happened. But just imagine the tens of thousands of people that did them that didn't get litigated. They won. Because you read the literature and people go, oh, there was that one case where everything blew up. Well, of course it happened. And remember, these are not rogue countries. These are countries that are involved in international commerce. This is not for laundered money, stolen money, insider trading, or drug money. These countries will pursue and will, through their court system, unwind those structures because they deserve to be unwound. We're just dealing with legally obtained money, properly taxed, that is protected from judgment creditor plaintiffs. And just think some county judge does not have a lot of power over international transactions. You don't want FBI and those type of agencies, Interpol, looking for the money because they will eventually find it and they will retrieve the funds on behalf of the money that was stolen. And particularly these type of people we don't want as clients. That's why it's so important to go to a legitimate law office, because if you go to an office that is not staffed by attorneys, and there's always somebody on the internet that will do something cheaper, something for very low cost, well, think of the consequence. That same low-cost place that does it for dirt cheap, that takes any type of client, your file is going to be sitting right next to the drug dealer, money launderer, everybody, and you know what's going to happen. Somewhere in the world, they're going to come in and raid that office and take all those files, and it has happened. We have had clients contact us that had their files and their offshore companies set up by these, these really illegitimate agents, not licensed attorneys, and their files were seized, and their bank accounts were frozen. And these were significant balances. We've had people with, for example, $50,000, $60,000 lost, and I told them, I said, you can get your money back if you sign an affidavit to FBI where you got the money from. But they don't want to do that. They'll rather walk away from the money. So it's so important that you deal with legitimate transactions, legitimate dealings, a licensed professional law office. Set up the account so you don't get involved with other people doing illegal transactions. Because you get the taint, right? You deal with people that do illegal transactions, and you're going to look like you're involved in that too. So keep it all legal, keep it all legitimate, and that way you'll be protected. Let's go back to the situation now if they were to somehow pursue that statute of limitations. Say you even did it pretty late in the game, and they somehow felt they had some type of burden of proof. Well, what we do in that trust, because that trust now controls the foreign corporation and the bank account and the domestic assets, we put in what's called a flight clause. It used to be called the Cuba clause. That means whatever jurisdiction it's in, if they really want to pursue it there, well, let's move it to another jurisdiction. So they fight you in Cook Islands, we move it to Singapore. They fight you in Singapore, we move it to Isle of Man. Fight you in Isle of Man, we move it to Bahamas. From Bahamas to Luxembourg, all around the world. They can fight you, they can chase after you forever. And there have been some big cases in the media. I think it was Imelda Marcos. What was that? Been about 15, 20 years now. They've been pursuing her, $10 million. I don't think they got a dime yet. And she's back in politics now. She's running for what? Senate. And her political party is back in power. So she waited it out and got back into government. Not a bad approach. So that's the flight clause. Duress clause. Say that judge back, remember he was going to order you to turn over that asset that we put into the offshore trust? Well, how do we avoid that if he wants to put you in jail and orders you to tell the trustees to turn over the asset? Well, what we do is we have what's called a duress clause. That means if you're under any duress, if the court is ordering you to turn over that asset, you're going to be disassociated with that trust. Remember earlier we're giving you complete control? Well, this is a time when you lose your control, because people always wonder what happens if we lose control. Well, this is exactly the time you're going to turn it over to the offshore trustees. But they're going to be managed by what's called a committee of trust protector. That means you're going to pre-designate a group of, say, 5 people, attorneys, CPAs, trust companies, and maybe family members that manage that trust. And that means the majority of those people are going to be offshore people. So 2 U.S. people, 3 offshore people. It takes, for example, a supermajority, 3 out of 5 or 4 out of 5 to make decisions on that trust. So all this time you're under court order to turn over that asset, you resign. Now there's 4 people left. 3 out of 4 have to decide what to do with that trust, most of them offshore. Well, you can imagine they're not going to give you that money back. They're going to give the money for other purposes, to your children, grandchildren, let it grow offshore, pay off your credit card, pay off loan balances when you need it. You still have access to those funds, but you have a pre-designated group of trust protectors protecting that fund while you're under incapacity. Your incapacity could be death, could be divorce, could be financial incapacity, or could be that duress from the court system. So the court system is ordering you to turn it over, you cannot do it. You are physically unable to do it. That is your defense to a court order. It's impossibility. It's impossible. You will sign that court order, it doesn't have any meaning. Everything's offshore. So that's the beauty of the offshore asset protection plan. So we covered the domestic, we covered the offshore, we covered some very complex topics. I just want to thank everyone for attending today. And this is a very exciting topic. It's always changing, always growing, so feel free to call our office anytime with any questions. I want to thank you so much for attending today and discussing asset protection.